Like a lot of other panelists, I want to express my appreciation to the people that put this conference together. I've learned a great deal over the last couple days listening to the other panelists. And I'm particularly pleased and honored, even though I'm about to run off the stage, to be up here with Malcolm Feely, who is an extremely eminent scholar in this field. He, among the many articles that he has written on this subject that made him famous, is an article he co-authored that said, pretty much, I think this is accurate. You can rebut me when I'm running out the door. That people who are fascinated by or believe in federalism are showing symptoms of, literally showing symptoms of neurosis. Anyway, the reason, I do have to say, the reason I'm running out the door in a minute is because I have to get back to Colorado to see my therapist. Since I'm afflicted with this disease. Okay, what happened to the Federalism Revival, and what's that tell us about the future of federalism, at least in terms of judicial enforcement of the principle of federalism? I think the place to begin is to remind all of you, I know this is unnecessary for many, but some of you may not even have been exposed to the nature of the Federalism Revival, or what's meant by that label. It began about 1976 and pretty much ended, although whether it's ended is an open question that we'll come to, but it certainly lasted till 2005, give or take a year. And in those years, the Supreme Court decided a number of cases in a way that protected state sovereignty as against the power of the national government. In two of these cases, the court limited Congress's power under the Commerce Clause to displace the state's power to regulate in a couple of important areas. One had to do with the regulation of guns in schools, and the other had to do with creating remedies for violence against women. Both efforts were labeled by the court as beyond the commerce power. In two other major cases, the court prohibited Congress from carrying out its regulations by forcing state and local governments to do the enforcement work, the regulatory work themselves. These so-called no commandeer cases, because they prohibited the federal government from commandeering the apparatus of state governments for their own purposes, are, I think, an example of what Professor Barber yesterday referred to as Calhoun's version of states' rights, because, which, by the way, he said was unconstitutional and maybe anti-constitutional. But anyway, these are examples of Calhoun's version because the court held that even though Congress was admittedly within an enumerated power, in these cases the commerce power, it was prevented from using its preferred method of enforcement by an independent constitutional principle, state sovereignty. There were also some cases limiting the power of Congress to subject states to suit, is viewed as being an indignity incompatible with state sovereignty. There were other cases in this period of time, but this, I think, are the main cases and gives you an idea of the nature of the judicial efforts. What was the significance, the overall significance of these cases thought to be? Well, at the very beginning, back in 1976, writing in dissent to the first of these cases, Justice Brennan labeled the court's protection of state sovereignty potentially and I'm quoting here, a catastrophic body blow to our constitutional structure. Sounds like a anti-constitutional move by the court to me. Major constitutional scholars, such as Professors Michelman and Tribe of Harvard, were more specific, describing the court as a threat to the modern administrative state. And Linda Greenhouse, the respected commentator, journalist, said, and I could find no evidence that she was being facetious in this, that the court was setting us on a return to the Articles of Confederation. So those were the hopes or fears back at the time of the Federalism Revival. What has happened since? There are some who continue to hold out hope, at least, for a continuation of the revival by the court continuing to impose significant limits on the national powers. In a recent case invalidating the Federal Defense of Marriage Act, Justice Roberts took this position when he took seriously Justice Kennedy's musings to the effect that maybe the subject of marriage is reserved to state regulatory power, and that's why Congress was beyond its power in the Defense of Marriage Act. It was outside its regulatory sphere because it was reserved to the states. So that, what I'm calling musings by Justice Kennedy in that case, gave some hope to people that the court was going to continue the Federalism Revival. Some have attributed potential significance to the court's dicta just recently in the Sebelius case to the effect that the forced purchase of medical insurance is beyond Congress's commerce power. Another effort, maybe, to limit the commerce power. So these are two sort of, they're illustrations of the kinds of, I would say, straws that people seize on and try to convince themselves that the court might be continuing or likely to continue the Federalism Revival. But the reality is this. Justice Kennedy, writing for a majority of the court, just recently held that there is a federal right to same-sex marriage. You've all heard of this case. Thereby having the court invade the very power to regulate marriage that he had earlier speculated might be reserved to the states. And in the same case, where there was dicta to the effect that the forced purchase of medical insurance was beyond the commerce power, a majority of the court upheld the same act, as you all probably know, as an exercise of the taxing power. So the dictum about the commerce power had no real immediate effect on the scope of the national power. Earlier than these cases that I've just mentioned, in 2005, Gonzalez versus Reich, the court upheld a national law prohibiting the private cultivation of marijuana for private use, and in doing so, reaffirmed the reasoning in the famous case of Wickard against Filburn, which had provided the rationale for virtually unlimited national power to regulate interstate commerce, because what was reaffirmed was the idea that even small effects on commerce, if they aggregate to have a significant impact on commerce, even commerce viewed as a sort of offshoot of another national regulatory scheme, a more elaborate regulatory scheme over, in that case, drugs more generally, that would make a federal rule consistent with the commerce power. This aggregate impact rule, as endorsed by the Gonzales Court, is an endorsement. It is the rule that provided the rationale for virtually unlimited national power to regulate interstate commerce. So the basic judicial justification for enormous federal power over commerce remains the law of the land after the Federalism Revival. So, in short, in my view, the Federalism Revival fizzled out. I believe this result was entirely predictable, and more generally, that the reasons for this predictability suggest that if a robust system of federalism is to be protected, that protection will have to come from the political process rather than from the court. To understand why I say this, you must think about the nature of the American principle of federalism and the nature of judging. As Colleen Sheehan said yesterday, the American system of federalism is based on the idea that both the national government and the state governments draw their limited powers to govern from the supreme authority, which is the people. The constitutional limitations established by the people are to be enforced in part by competition between the national and state governments. So American federalism is a process that involves conflict, uncertainty, and indeterminateness. It's the consequence, the outcome of political conflict between two partial sovereigns. To engage in this competitive process, both levels of government must be seen as legitimate, but partial embodiments of the sovereignty of the people. For a number of reasons, the justices of the Supreme Court are not well situated to protect this complex and messy system of dual sovereignty. First and most obviously, the justices are a central part of the national government and naturally are inclined to view state governments as less significant, somewhat distant, and even dangerous. And I'm not making this up. If you read the relevant cases, you will see that states and the politics in states are often explicitly described in those ways by the Supreme Court, including as being dangerous to the rule of law, to the American system of government, as being dark and nefarious. I could go on, but I won't. But it's you don't make this up, it's in the court's opinions. Second, the mind and the role of the judge are inclined towards authoritativeness, definitiveness, orderliness, certainty, and compliance. If you don't know what I mean by that, become a lawyer and appear before a judge, and you'll pretty soon know just what I'm talking about. These characteristics are inherent in the nature of the judge's role, training, and experience, not to mention the fact that they're psychologically pleasing. and make judges naturally unappreciative, if not downright hostile, to a system of political competition meant to resolve some of the most basic issues of constitutional meaning. It's too messy a process to seem legitimate and worthy of respect to the judicial mind. Moreover, since Marbury versus Madison, the court has gradually set itself up as the embodiment of the sovereignty of the people. Again, I'm not making that up. You can look at case after case, and the court says so. So, in this regard, the court is, so to speak, plainly doing a large part of what the states are supposed to do under a federal system. They have displaced the states as the protector, or as a primary or even the primary protector of the constitutional system and the limitations in that system on the national government. Finally, the decorous and rationalistic intellectual tools available to the justices are not likely to be effective in protecting the federal system, even if the justices were consistently inclined to do so, which they're not. Judges rely heavily, as most of you know, on conceptualizations such as the distinction between attenuated effects on commerce and direct effects on commerce. History shows that these kinds of abstractions have little constraining force when set against empirical realities and popular demands and the other potent economic and cultural forces that drive centralization. So what I'm saying is the judicial doctrines that courts sometimes do use to justify restraints on national power tend to fall away. And history shows this consistently. One after another of those doctrines or concepts tends to fall away in the face of brute political and economic facts of life. In short, despite the glimmer of hope that can be teased out of the Federalism Revival, vigorous protection for the American principle of federalism will have to come out of the political process. The most, I think, that we can hope for from the Supreme Court is that in a minor but somewhat important way, it occasionally might help to maintain the public understandings essential for the political process to protect the role of the states in a federal system, because that political competition I'm referring to will not work effectively or for its desired ends unless the participants have some fundamental understanding of what they're struggling about and why. I think the court has some minor role to play and did play a minor role during the Federalism Revival in inculcating, in distributing those understandings. So I come back to Ken Ivory's point about teaching the fundamentals. I think the court can't be counted on to do very much, and history shows that, and our understanding of the nature of judging shows that, but they can be counted on to contribute maybe some minor understanding that is essential to protecting the American system of sovereignty. And with that, I'm off to visit my therapist.